A great number of people in Mumbai live in tenanted properties. And today we are going to discuss the Maharashtra Rent Control Act and the law of tenancy to protect and to safeguard both landlords and tenants. While some of you may be the more fortunate ones to be landlords, others are largely tenants. And therefore, let us quickly look at the definitions of landlords and tenants. Firstly, under the Maharashtra Rent Control Act 1999, who is defined as a landlord? A landlord is any person who receives or is entitled to receive rent in respect of any premises, whether on his own account or on behalf or for the benefit of any other person, or as a trustee, guardian, or receiver for any other person, or who would so receive rent or be entitled to receive rent if the premises were let out to a tenant. Now, let us see what this has to say. One is a landlord is a person who is entitled to receive rent either on his own accord or is legally entitled to receive rent by virtue of being a trustee, a guardian, or a receiver to a person or a trust or a body corporate that is entitled to receive rent. Next, let us see what is a tenant or who constitutes a tenant under the Act. Any person by whom or on whose account rent is payable for any premises and includes any person who is a tenant, who is deemed a tenant, or who is a subtenant as permitted under a contract or by the permission or consent of the landlord, or who has derived title under a tenant. Let us proceed to analyze this definition. One, a person who is a tenant, of course, is a tenant. A deemed tenant is also a tenant. Very importantly, the concept of subtenancy. Now, by and large, unless there is a contract to the contrary, a specific contract for the purpose of subtenancy, or express written permission from the landlord for subtenancy. Subtenancy is also a ground, if not expressly agreed upon, for termination of the tenancy. Subtenancy, by and large, is not allowed except if there is a contract to the contrary or if there is expressed permission for subtenancy from the landlord. And of course, a person who has derived title of tenancy under a tenant. This could mean legal heirs who were residing with the tenant at the time of the death of the tenant, or successors in law, or for bodies corporate or tenanted properties owned by trusts. Moving forward, let's discuss the concept of standard rent. Standard rent under Section 7 of the Act says the rent fixed by a court under various applicable acts, inclusive of 5% increase or rent at which the premises were first let out. If you are a landlord, you would further be warned that any charging of rent in excess of standard rent and permissible increase is illegal and punishable with imprisonment not exceeding 3 months and with fine not exceeding 5,000 rupees or both. If you are a tenant, it is imperative that you pay your rent every 90 days or at least once every 180 days if by customary agreement you have been doing so. If you have been paying rent on a half-yearly basis, that is 180 days, or on an annual basis, then you may continue to do so by customary acceptance. However, it is necessary that if notice is served for payments of rent, you are under statutory obligation to make that payment within 90 days from the date of notice. Section 15 of the Act makes it extremely clear that if a landlord serves notice for non-payment of rent and within a period of 90 days from that notice, rents are still not paid, it is a ground to file a suit for recovery of possession. Standard increase in rents. How much is the standard increase allowed in rent? It is 4%. However, if there are structural repairs or other expenditure, the landlord may fix an additional repair charge not exceeding 15% per annum of the expenses incurred. This should also not be in excess of 25% of the standard rent. We will now look at the grounds for recovery of possession of tenanted property. Section 16 of the Act spells this out in detail. The first is the tenant is required to take the due standard of care, and if he does not take the due standard of care with respect to the property and he fails to protect it, this would be a ground for recovery of possession. Clause B of Section 16 says if the tenant, without the landlord's consent given in writing, erected on the premises any permanent structure. This is generally in respect of lands where illegal structures are created without the permission of the landlord. One may also be careful about creating structural changes in tenanted property, or what one may call non-tenantable repairs. In case your repairs are beyond tenantable repairs or beyond the standard maintenance required by you, such may amount to a ground for recovery of possession. Nuisance is another important ground, and if the tenant has caused nuisance to the landlord or to any of the adjoining properties or co-tenants in the building, in such a case, possession may be recovered. Another very interesting ground for recovery of possession is if the tenanted property has not been used for a period of 6 continuous months. In such cases, on the completion of 6 months of non-occupancy or non-bona fide use of the tenanted property, the landlord may sue for recovery of the tenanted property. A suit for recovery of possession may be filed. Another ground for recovery of possession is where the tenancy is created by virtue of the tenant being an employee of the landlord. In such a case, on termination or expiration of the agreement of employment or the terms of employment, the tenancy ceases to exist. Clause G of Section 16 clearly specifies recovery of possession by the landlord for his own bona fide use. The landlord may also recover possession if the tenant has sublet the tenanted property at a rate which is higher than the permitted rate of standard rent and standard increase. We are then drawn to a very interesting part of the subject of tenanted properties, and that is tenantable repairs. Many properties which are given out on rent are in a dilapidated condition, or sometimes they are not properly maintained. However, one may note that it is the duty of the landlord to maintain the property in good and tenantable repair. This is a statutory obligation laid down by Section 14 of the Act. However, if the landlord refuses to maintain the property, the tenants may proceed to repair the property to such extent as is necessary, and such tenants may deduct the expenses of such repairs from the rent or otherwise recover them from the landlord. We then go to the last part of this video, which is litigation in respect of tenanted properties. The first question that you would ask me is, where do we file suits in such matters? For Mumbai city, it is the Court of Small Causes. Now, if you are a tenant and the landlord refuses to accept standard rents, or there is an issue of dispute of tenancy between yourselves and the landlords, you need to file a declaratory suit before the Court of Small Causes and ask the court to declare that you are the bona fide tenant or that you are liable and entitled to pay rent to the landlord. If you are a landlord and your tenant has violated any of these provisions that we discussed earlier or other provisions of the Act, you are entitled to a suit for recovery or a suit for rents. In the case of recovery, you file an eviction suit before the Court of Small Causes. However, you need to keep in mind that whenever you file a suit before the Court of Small Causes, you need to establish a relationship of landlord and tenant. You could either be the tenant suing the landlord, or you could be the landlord suing the tenant. But either way, a relationship of landlord and tenant, or tenant and landlord, needs to be established to file a suit under this act before the Court of Small Causes. I do hope this gives you some perspective on the rights and duties of landlords and tenants.